took me.
That's not very mad.
And it was funny because our coach was like,
You're running
I
one?
know it's working right.
You're going to be the sponsor? You're the guy?
Writing it and doing the.
Like there's no hack to that. You want to know it's working right now? Working.
Now I'm not
Working's working.
lazy.
Right.
Hopeless. Like, I feel like that's all it is. It's like constant. You're not good enough. You're not
Hello.
good enough. You're not good enough.
Mr. Cherry.
Hello.
Hey, did you get the memo about?
15 seconds.
Did you get the memo about pizza?
So I was late.
Oh,
He did get the memo.
you did get the memo. You're in contempt, sir.
You're a kid.
Yeah, it's a Monday.
It's a Monday.
And if I can't support a local business,
You're in contempt.
Oof.
I didn't even eat.
You ready to go? Okay. Ladies and gentlemen, welcome to the Planning and Zoning Commission for a special meeting on February 6th. I'd like to first establish a quorum, which we do have, and I look to approve minutes for January 17th, 2023.
Mr. Chair.
Billy,
I'd like to make a motion to approve minutes for January 17th, 2023.
first we have a second.
Second.
Second by Scott. All in favor? Aye. Any opposed? Hearing none, minutes have been approved. Recognizing any persons not on the agenda? Nope. Okay, moving on. Any conflict of interest this evening from what we are about to discuss?
None.
None. Okay. We have no public hearing, no new business, and we're going to go all the way down straight to 9, which is what we're here for. Council, thank you for being here with us. So the Planning and Zoning Commission has requested a joint meeting with City Council. The purpose of the meeting will be to discuss the city's zoning title amendment application to allow all city land uses. Mr. Chair?
All right, thank you, Mr. Chair. Mr. Chair, Mayor, City Council, thank you for being here. The reason to have you today is the Planning and Zoning Commission has done extensive research and has had extensive conversation about a ordinance which would allow the city to work more effectively as we build our facilities and administer goods and services that we are obligated to give to our citizens. This is the latest draft. The initial draft was fairly open. It was, if it's a city facility, goods, service, we can go ahead and do it. There was some thinking that if there was to be a city council who was less than stellar, that they could potentially do things that were not in the best interest of the citizens at large. Such as, the example would be building a concrete crushing area right next to a preschool. That isn't something that we wanted.
Hey, Brock, really quick.
Yes.
Do you call meeting order to if we're going to vote on anything?
No, we're not voting.
Okay, this is just
Yep.
informational only.
Yep.
All right.
So what I did was I went through the land use chart, looked at all the big and scary land uses, which would be controversial, and made sure that those were a conditional use. That is what is being seen before you today. And essentially, before we go ahead and we post this and we do the hearings, we wanted to make sure that we were as close as we can be to being where we believe the ordinance should be. So I have forwarded this to all the city council members. I believe I've discussed it with all of you. Do any of you at this moment have any comments, any thoughts on it? Anything else you would want to see?
Mayor, do we need to be formal?
No, this is informal, or let me rephrase. Sorry, let's suspend the
You
rules.
also say suspending
Yeah.
Rob's rule of order.
So you talked about looking at the big and scary
Yes.
land uses. As I read through it, though, I see that are you really only suspending those for residentially zoned R1 through R4,
Yes.
LO, and R?
Those are all for residential areas.
So the big and scary uses don't really apply to anything other than that, and the city would still have an outright permitted use. for
That
commercial and industrial use.
is correct as presented. Do you believe that they should expand into the
Is it-
commercial areas?
Is this the time for my opinion?
Industrial? This is precisely the right time.
I don't like any of this. I don't believe that the city should have more rights than the people that were elected to appoint or to represent. And for us to just have outright permitted uses on everything, no, you're not gonna get my support on that.
I think one of the things that we discussed in earlier planning and zoning meetings on that was, in terms of initially, that first draft did really give outright permit to everybody. I think some of our pushback on that was, if you were going to have these factors near residential in R1 through R4, that those people do deserve their say. That it should be going through the process of conditional use permit, should allow the public to come in and give their yay or nay, provide their input, and have the elected bodies vote appropriately based on that input. And that, I think, is specifically why I know that, for at least for myself, that I was happy to see us change that from outright permitted and later to include the footnote of R1 through R4 as conditional use permit required.
And I do remember the conversation that we had up here was the property would be owned by the city. So it's not like the city is buying the property, it's already owned and bought by the city. So for us, I was kind of, Dan, I'm kind of going the same way you did, in the sense of I don't feel as though the city should have any rights to be able to just say, this is what we're doing, and that they should listen and talk to the community first, which is why I had a hard time with everything's permitted. However, I do think that within the C1 through I2, I think if it's just like anything else that comes in, they have to come to us and we have a conversation, they show us everything and that they want to do, and the developers come through. But if the land is already ran by the city and owned by the city, I don't think in those zoning areas it would be a problem for the city to do whatever they want to do. I think in the residential side of things, I think that's a little bit more sketchy. I think that residents shouldn't have a say, and it's more conditional than permissible, in my opinion.
Any other thoughts? This is all open.
No, I think you hit the nail on the head. I think the residential gets a little hairy. Having a personal home and not having a right to be able to say what goes next to it that's ugly business. But I think I can agree with Topher when he says that the other one being permissible, it makes sense.
So then something like, for example, the pool, let's say, on the off chance that they wanted to come in and bring in something completely different than what was there already, then we would still have to go through the entire public hearing process and notify everybody that's nearby, hey, this is what the city is going to do. I don't find a problem with that. I would hope that most citizens that live in those neighborhoods would want to know what is going up in that area, or would want to know if something different is going up than what was already there.
I also think it's important that the reason that we wanted to do this is because we're not looking at this council. We're looking at 10, 15, 20 years from now from people that we don't have a say on. We're not going to be on the board anymore, and we're putting this in writing that is going to be what they are going to be looking at. So this is setting precedence in my mind of what it is going to look like in 10, 15 years when we're not here, and I want to save a heartache in the city and our community. So,
Any other thoughts?
Christina, when you talk about you think the people in those neighborhoods should have the right to know, are you distinguishing between have the right to know and have the right to say?
Yeah, I mean, when they get that public hearing notice, they are basically being put on notice that they can come to the meeting to be able to voice their opinion on what's being planned to be put in there. So I think they have the right to both, to know both what the city is planning, but also to be able to go through that public hearing process if it's in a residential area, so that they can come in and go, I like it, I don't like it, maybe tweak this, tweak that, whatever.
We ran into a problem once before, Brock. I don't know if you remember, where legal made sure to point out to us that at this particular meeting we held a public meeting, and it was not a public hearing. They called it two totally different things, and so I just want to make sure that those two things are clearly defined. That we don't just get to announce a public meeting to tell them, but where they have a right to give their input as well.
Jeff?
So with respect to the park, pardon my slouch, but I'm trying to keep my legs straight.
Stand up, would you? Come on now.
With respect to the park, I assume that that's zoned residential.
Depends on
The
which
park
park.
where the pool is. Well, that park is, it's next to the hospital, but it's zoned residential. So if it's zoned residential and the city comes in with one of the, we're gonna put a new police station or something there, so you would, if that's likely to have, if that's likely to be, has the potential to be incompatible with the surrounding uses, then it should be reflected in that chart. And again, city uses is a subset of all the uses in the universe. So the things the city can do, you could put a, let's say you develop your own bus station. Let's say you want to, it's too short for an airport, but a helipad, an event center, so it's already being used as a park. But what I'm getting at is what should be put in that land use chart are those potential city uses that could cause it could be incompatible with the surrounding uses. In this case, in the residential areas, you're going to lump those together, you're going to describe what they are, instead of just city uses. I think you have them maybe bail out. In that case, there will be a C in there for the residential zones. And so they're required to get a public hearing where they have a statutory right to be heard. They get notice and they have an opportunity to be heard. A public meeting is a more informal thing, scoping thing, and that sort of deal. But this still would preserve the right to be heard and to be noticed with respect to a residential zoned area. With respect to the commercial and industrial areas, there's less risk that the city is going to be infringing on someone else's rights by going into and doing a permitted outright activity without doing a hearing. Because if you're sandwiched in between two commercial buildings and you're going to open the city's new water department, you're not doing anything different than what would have occurred normally, right? So making that city use a permitted use, and that may already be consistent with the commercial zone. Maybe it's inconsistent with the industrial zone. That's I think what they're angling for. The key is, and you hit that point, which is the one I brought up to Brock initially, is making all city uses outright permitted everywhere in the city could potentially, not will, but if you put the street department's concrete grinding plant next to the funeral home, you're going to have an incompatible use. So.
No, I think that's great. In my, I've seen this implemented in different cities to a point. I can tell you there's some city services that we provide which no one will ever like. A great example is a fire station. We all love firefighters, but no one wants to live next to one. But where we place them is extremely important. And that's a situation where having something like this gives decision makers more discretion to make good decisions, which are unpopular, and they won't be fun public hearings to go through. So I understand, yes, the city should not get a get-out-of-free jail card for everything. However, I do believe in democratic republics, and I believe they recommend council people to serve their best interests and to have every decision that we do when we administer those goods and services voted upon. I don't necessarily think that's the overall correct way to govern.
Well, Brock, you're giving them direct democracy, so the residents come in and say nay or yay.
there's going to be some city services, like you said, like a fire department, that's going to over trump some of that, because you can't have a fire department in the middle of the field with no houses because of safety. There's got to be a fine line in between, but then again, you got, like Topher said, you got to get all the citizens to make opinions on it to guide the decision.
So, I just want to clarify something. The public hearing process for conditional use permits is not a direct democracy process. It is a way for them, you are receiving evidence,
Right.
and then you weigh that evidence, and you ultimately decide the weight to give it, and you render your decision. And the same happens in City Council.
Yeah, but they
Don't
give an
tally,
opinion.
you do not.
We're not
You
telling
must
them.
not go, there were 5 in favor,
Right.
4 opposed, because
But-
that's not.
But I guess my point on that was, and maybe I'm blurring that definition a little bit, is it giving them opportunity to make their voice heard.
Right.
That's what I meant outside of just doing a vote. Sorry.
Yeah, notice.
Thanks for calling me. I'll put my admin head back in.
Well, I get vigilant when there's,
Right.
when you weigh testimony by volume, it's like, no. That's not
I guess this is, at the end of the day, it's common sense. You know, I don't think anybody sitting up there would put a asphalt crushing plant next to anyone's residential, right? I mean, I guess I'm more, can we put depends on what you categorize. Is it an amphitheater? Is it a band shell? Is it a stage? Is it I'm just thinking outside the box here. Is it a playground set? Is it a pool? Is it a pickleball court? I think those are the simplistic things that we're talking about when it comes to this. It's not.
So one of the things that we brought up, I brought when we were talking about this, was the city needs a new garage for their cars maintenance, and they have a spot. Let's go with the city pool, since that's what we're talking about right now. They go, you know what? We have this land. We could put a garage there, and I mean it's open, it's wide, and we can use that also for our maintenance place as well. You're also right in the middle of residential, and I don't know if a lot of people would want the cars, smell, the oil, and all that kind of stuff. And so that's kind of where, because I'm with you, pickleball totally makes sense. That makes sense to me, but I like to lean towards people like to have sense, but there's also people that don't have any sense, and I want to guard from that.
I agree.
So-
I agree.
So for what if you're not in the middle of a residential area, you're right on that line where across the other side of the street is a residential area, or where you want to put that firehouse is a commercially zoned area.
Then it falls in the commercial zone.
And they're gonna come out, sirens blazing, get into the call as fast as they can. Right? I think those residents on the other side of the street have a right to have their voices heard.
I don't disagree with you. I don't.
So with respect to your, like, individual pieces of equipment, I think you can safely lump without running afoul of protecting people's rights, uses. And a use as a park encompasses all of those things that you said. So if all of a sudden they buy a block over by the high school and tear all the houses out, and like, we're gonna put a city park here, the expectation is it's possible. And that should, I think in the past that has been a conditional use, and it would be in a residential area, because a park is going to have an impact on the neighbors. And so, but you wouldn't have to get so fine-grained to be a band shell, an amphitheater, a pickleball court, or what have you. It's just a park and any other things. I mean, I can hear all the concerts in Carl Miller at my house. Not that I'm opposed to it, but what I'm getting at is you have an expectation, but you also have a right to know, if I'm living in a neighborhood where there's no park, then tomorrow there's gonna be one. But I don't think that same expectation arises in the case of commercial and industrial property. But I also think, with respect to your comment about the boundary, policy-wise, you're right. Legally, boundary's a boundary. You're in the county, you're out. You're in the city, you're out of the city. So you're in the zone, you're out of the zone.
Rich, did you want to say something?
I think a quick example of park. So let's use, here's a great example we have, Legacy Park. it is a park. Being able to put a band shell, a gazebo, whatever we wanted to. So because we had to put a gazebo, we had to come and do, get a permit to do that, and go through P&Z and get a hearing and all that. Well, the person across the street didn't, they were saying, well, you're gonna block my view of the mountains now. But that, a great place to put, it was right in the parking lot, right by where everything was. That's where the band was, remember, that's where we put the gazebo eventually, because that's what we did. But there's an example of, it's a park, those are perfectly things that need to go in a park. That was the spot for it. It was next to the playground, so parents could sit underneath it, watch what's going on in basketball courts. That's where it had to go. So, but we had to go through all that stuff. But
I think,
there's an example of where we really didn't need to go through all those because it's a park. That's a use that we can put in a park.
I think, I was in the council when that happened, and I think we voluntarily went down that road. I don't think we had to, but I remember getting the letter from the lady across the street about that. Turns out you can still see the mountain though.
Right.
From our second floor.
So, Dan, let me ask you this. If it was residential, would you be more apt to just go, okay, we'll make it conditional and residential, but permissible through commercial I-2? Like, if it's on that boundary of commercial, you're in commercial or you're in industrial, it's just permissible for the city. If they want to put up a garage for their maintenance, if it's in commercial industrial, do it. You don't need to come here. But if all of a sudden it falls within the residential area, yeah, that needs to be conditional, and we need to have a hearing. And we need to also make sure that we're following this bad boy, right? So, thoughts?
I don't understand your question. I'm totally with it for the residential stuff too, with I think what everybody else is saying.
Yeah.
Definitely needs this conditional use permit. But the part about commercial and industrial?
So instead of making everything all permissible, I'm saying residential is considered conditional. So they would have to come in and they would have to put a permit in. They'd have to have hearing.
Right.
But if they decided to go in a commercial or through industrial spot, that they don't need that. It's permissible no matter what. No.
Not to me. Depending on what they like Jeff talked about, within the already kind of like allowable or conditional use for the general population. Right? If you have to, I don't have a good example on the top of my head, but in a commercial zone, if you still have to obtain some type of a permit from the city for that area, like, I don't know, you guys have any examples? I forget what you'd have to pull a permit for. I would just
Drive through?
Yeah,
Drive-through.
drive-through.
Yeah.
Sign.
A sign.
Sign, yeah.
I would expect the city to respect the same that we ask of the people, and we've had a few sign requests come before us, like the one at Central District Health. They brought in one recently. Our big new sign downtown. Did we pull a permit for that? Is that required by ordinance currently?
It's art. See, that's just it. It's tomato, tomato. Is it a sign? Is it art? Is it?
It's a sign.
It's a sign.
Looks like a sign,
Okay.
I think.
I agree. Kind of like it is what it is. Like we're not gonna let somebody put a sign out in front of like the McDonald's sign isn't art. Right? It's just an arch that's colored yellow and red. It's a sign. So if we require any business to do it, I just think we should too.
So
Well, the one we denied was the billboard on American Legion, and then they want to do one somewhere else too, didn't they?
It was the standard point.
So
Yeah.
one of the differences is, and one of the things that where most cities, that's one of the blanket exemptions they give for signage, is that the city is embarking on signage to inform its citizens. And it's fulfilling part of its obligation as a governmental entity, to direct people to whatever, it's informing people. And so it's part and parcel of a government activity. So it's a little bit different than other signs. So in terms of compliance with not interfering with traffic and that sort of thing, the government has a right to do a little bit more than the average person does when it's trying to fulfill its statutory duties.
So it stands a little bit differently in terms of asking permission.
I understand that, but bottom line is our body of the city council will have the ultimate control in deciding.
Yep.
I think they still have a right to give some concerns that we may not be thinking of. The four of us plus the mayor may not be experts in the thing that citizen wants to talk to us about, and so I want to hear what they have to
I
say.
think the ask is, in this instance, and I have no position on this, but what I'm trying to get across is the ask is, should that engagement with the public with respect to outright permitted uses be permissive for you or mandatory for you? Because if it's mandatory for you as a conditional use in the zones in which it's conditional, you trigger these statutory 15-day notice and hearing requirements, and you can end up delaying a project when you may not want to. Versus if the risk of installing or putting something up is low to minimal, you can voluntarily engage the public in those same things without triggering those statutory deadlines. But that's completely up to you. Again, I think that's kind of the ask. So.
Making it optional decreases the cost, right? The notices to go out to the public, to the residences or the other businesses, or the public entities that we have to notify, it decreases that cost. And every government body is probably excited about decreasing the cost, but to what extent and to what true cost is it? So I'll stop running my mouth. I think you probably knew. I made it very clear where I stand on it. I appreciate citizen input every time it comes before me, whether I agree with it or not.
Can I just make sure I understand what you're saying? So, is it just, because if the city wants to build something, you're saying they should have to go through the same process?
Right.
Yeah, okay, I gotcha.
Unless it's already permitted.
By the
If all
by-
those-
by the
that-
current
that you-
Yes.
zoning titles
Correct.
amendments or whatever, yeah.
Yeah.
Okay, so what would be examples of something that wouldn't fit within our guidelines and that the city would have to potentially go down that path? Give me an example.
An example could have been the expanding our public works site that we have with all the various uses that we have in that area. Would probably need a conditional use permit if we wanted to expand our footprint. That's one right off the top of my head.
Like the one out here by the dog pound?
Mm-hmm.
Why?
Because of the zone it's in.
Because it's in residential.
Yeah. So the expansion for the certain uses tied to that could trigger a conditional use.
Okay, so then the city would have to go through that process anyway.
So we would have to go through the process of the conditional use. We'd have to have that before we pull any building permits. It's
Depending on what the nature of the expansion is.
Yeah.
So if the initial conditional use permit is have a city shop, then I don't see any limitation on expanding it.
And
Without
then give me
seeing
another
the-
example.
Yeah, but,
Next.
well, but he's,
What I'm getting at is what is the actual, how is it far-fetched? Is it far few in between that we actually have to go through this process?
yeah.
Because
so-
everything else is
So Glenn's
permitted.
Ferry just wanted to put a dog, maybe they didn't do it, but a dog pound is a great example of something you absolutely want.
Right next door.
It's a conditional, well, it's a conditional use.
Yeah.
A kennel is a
Okay.
conditional use.
Okay.
So,
So you'd have to go through that process
Right.
regardless.
mhm.
Okay.
But there's permitted uses. So I would say if the water department here was to move to a storefront in downtown, you wouldn't, it's a retail storefront or an office, it wouldn't trigger a conditional use permit.
Would you
If-
be okay with something like
If
that?
the water department was to open a drive-up window, even in a permitted zone, which we've found this happen in other places, then they need a CUP just for the drive-through portion of it.
I understand. Okay,
Does that make?
I'm okay with it.
So my question then becomes, and I guess I'm not understanding it all the way through, is if it's permissible, does that mean it can happen no matter what? Or is it permissible based off of what we say is permissible within that zone?
So the first order of business, what Brock first brought is, if it's a city use, you just put city uses, PPPPP all the way across.
Well, that encompasses a wide universe of activities, from dog shelters to helipads, to police stations, to fire stations, to water departments.
Signs and drive-throughs.
And signs and drive-throughs. So, what was your question again? I started down.
Well, then that mean if it's, if,
So if, right now, if there are permitted uses, let's say you don't do anything with it. There are certain uses in certain zones that are permitted, and some are conditional and some are not. So the city can currently do those without asking anybody if it's a permitted use. So he's modified the ask a little bit. City uses, whatever they may be, in the residential zones would all require a conditional use permit. And then the remaining uses in the other two zones, is that right? Would still require a conditional use permit. But if you look in the table for the commercial industrial zone, if you do an activity that's already a permitted use, the city wouldn't have to. The same as anyone else that was in that zone wouldn't have to. So it wouldn't be everything you do requires a conditional use permit, just those things.
everybody else has to have a conditional use, okay.
So Jeff, what if you had a situation that you need a building for public safety, public good? The residents come in and say they don't want it. Who trumps, who has the trump then? Would the city trump because it's over for public safety?
No, if it's a permitted use, again, you have to decide what the building is and then look at the table.
Let's say if it's a new subdivision, let's say, just kind of use an analogy, down on Fifth West, all that was county, is now its own city. They want to put a fire station in a mess of the monolithic, subdivision there. And all the residents like, I just built a new house, I don't want a fire station or X here. But for fire services and for the call of the city to meet their fire standards, they would need something that close.
Well, I think, aren't fire stations in the code now, in the zoning table? I don't know if they are not.
But these are all the excluded in this ordinance. So obviously, this pretty much trumps the common sense, because we all know you're not gonna put any of this in a residential.
The reason I asked that,
Your
Jeff,
question about what trumps it is if it's a conditional use, and you're trying to see that they've met the conditions, that they've mitigated all the demands, then what trumps it is the governing body and the
reason I asked that, I can't think of the subdivision off the top of my name, but they wanted to dedicate some land for a fire department. So would that be a part of the CCNR that they know if they build that house, just like with the lagoons, they have, there's a possibility they might get a little more fun.
Their plat is gonna say dedicated for a fire station.
Right.
And so any owner is gonna know that that's what it's gonna be used as. And then when a subdivision is created out of bare land, it's zoned by this, it becomes zoned by this body. And then that development agreement, by development agreement, they can provide for uses that aren't otherwise contemplated and add that fire station. Didn't we have, I feel like we had that exact conversation.
We did to an extent, and one of the questions that came up in that was, say that portion of the plat that was going to be dedicated to the city for the fire station, that if the city then decided, hey, you know what, we don't need a fire station here, what we need is a well pump here, or something that would create a nuisance that was outside of the scope of what was originally cited. So, fire station, and then
Okay, earmark it for that, but needs.
earmarking it for the fire station, and then creating it for another purpose that may create some nuisance for the residences within that R zone. That, I think, was our question of,
What trumps is what is initially there, and the person who dedicated it is going to, that's what you have to use it for. But the secondary use, there's room here for a well, that isn't a.
We'd have to go back through the process, is what you're saying, in order to change that.
The well
You need a
is
conditional.
intrusive.
He's just an example of something that is.
right, I mean, and that could be.
I think the neighbors would disagree with you.
Yeah. Well, we have that location that's a flat piece of concrete. I mean, it's an eyesore. So if I'm the neighbor, I don't want to see an old well site in a neighborhood either.
Yeah.
What's that one that we're trying to, the one we abandoned?
Yeah.
It's sitting over there off of 10th Street.
Yeah. Who wants that one?
An old well, those are safe and fun.
Right? So we're working on that mitigation process.
So,
The examples about residential stuff, I don't think like it even needs to be talked about. Really, it sounds like we're all on the same page. Like residential needs to be, CUPs.
Yeah.
But I go back to similar examples that I use. Our giant new green mountain home sign. You use your imagination. The other side of that street right there is zoned residential and full of neighborhoods. Right now, you're gonna have light pollution blowing in, but by law, it may be allowed, but by policy is what I'm concerned with. Is like, because the zoning table now requires signs to be conditional use permits.
Yeah.
So if we're doing the same thing with a residentially zoned on the other side of our commercial zone, that's where I draw the line, right? Is that we're putting up a sign because the law says we have the right to as a city, but those residents have a right to not have light pollution or noise pollution from a siren of a vehicle or whatever. But sirens are bad examples because everybody, law enforcement, medics, and fire have the right to use those. I get it, but
so right now, this is kind of illuminating.
What's that? Never
So,
mind.
Public buildings and uses are conditional and limited office residential, conditional in C1 and permitted in C2, C4, C3, and I1, conditional in I2. Recreation facilities, there's no consistency. Public recreation facilities are conditional all the way
throughout.
across. All the way across.
So if we were to someday do a rec center, wherever we put it, we would have to do a conditional use permit.
Jails,
not by what you've written.
Not by what I've written, by what's currently there.
currently there.
Yes.
Jail and detention facilities are conditional in C4, permitted in industrial zones. And then, the next line up, house church.
Yeah,
What is
those,
that?
Churches-
What's a house
churches,
church?
right?
I don't know, but I'm going.
Government building, industrial character, permitted in I1 and I2, conditional in C4, and not permitted anywhere else. Government office, non-industrial character, permitted in C2, C3, C4, I1, and I2, and not permitted anywhere else. So that's,
So I guess the short question right now is we kind of have a general feel. Right now, we can take what I have and we can take it through the process. The reason for this is because if we know up front that this is a no way, I don't like it, never, ever, ever, we want to try to finesse it as much as possible before we post it. So what my invitation would be to planning and zoning commissioners and city council alike, if there's any common ground, if there's any halfway, let's see what it looks like. Not everyone has to agree on everything, and that's totally fine. That's government. But this is us just trying to create the best thing possible and to be effective. So I would invite anyone who has any other comments to come see me in my office. Let us know what's there. We'll see it. We'll hash it out. And I appreciate your time because I don't think I'm willing to put this on tomorrow. I would, if there's anything that we can do to make it better, let's make it better. So anything else?
I might have one suggestion on that, and Jeff, maybe you'd have some language as to this. In other parts of our code, we have, I guess, what you would consider like a radius of proximity to things. One of the things that we were talking about at one point was signage or a specific type of business that had a straight line to a church. And the question was essentially like, does this 300 or 500 foot exclusion zone, like, does that apply in the sense of I guess that context? To Dan's point, like, say we have R1 and across the street it begins a C zone. Can we put an exclusion that says to avoid things like light and sound pollution within So the R zones plus a 500-foot radius in any direction from that border, and that might provide some of that buffer to that.
You
So-
can. The radii and distances for churches regarding alcohol facilities, that's in a
That's what it was.
statute and not in the city code.
Okay.
And it doesn't give them absolute veto authority, it just requires that they
But it required
notice.
the notice, the permit, the hearing, and so on. Could we apply that same language or similar language in this case?
You could.
Yeah.
Like that's, so if we don't want it to be that fine line, we could say, or if you're within X amount of feet from
There
a
was
certain district.
There used to be a provision,
That's
what made me think of it as contractor's yard, and Mike brought this up, and he assumed that you could have a contractor's yard in a residential zone, and it was regulating a contractor's yard in a commercial or industrial zone that abutted a residential zone. So there are places in this table that regulate conduct in commercial and industrial zones that are adjacent to residential zones. And so you can build that into these provisions as well.
i.e. West Fifth South. Where
Yeah.
you live,
West Fifth North.
or North, sorry, yeah.
One of those directions.
Yeah, it's over there.
Sure.
Yeah, that's,
That's a good.
are you
that's a good
interested in
starting
looking into
spot
that?
for
Is
me
that a
to
good starting
talk about.
spot?
Absolutely, like
I
a
like
buffer
that.
zone or something. Right. Jeff, can I go back to your comments you were making about the bar and the church situation?
Yeah.
You said that it's a statute, not a regulation by the city, but you said something about they still have to have notice and all that.
Yeah, let me pull the statute.
Yeah, it's a
Is-
state statute.
Remember Raymond's?
That's where I'm going with this, is that, that bothered me because there is no requirement for notice to the public, if I remember correctly, because the state says you can't do this unless city council gives you authority.
Right.
And the city council gave authority without public notice. And that's why I was shouting from the mountaintops that day, is because the church didn't get notice. They just heard about it and made a last minute run to City Hall to say, hey, wait a second. And the majority of the council chose to proceed without giving anybody the opportunity to truly speak.
A
And
license should be issued for any place where beer is sold or dispensed to be consumed, whether conducted for pleasure that is within 300 feet of any public school, church, or any other place of worship measured in a straight line, except with the approval of the governing body of the municipality, provided that this limitation shall not apply, subject to licensing can therein. So in other words, they can't move to them. Oh, maybe there doesn't require notice.
Well,
I
No, it
feel
doesn't
like I
require
was in a
notice.
situation in Kings Ferry where licensee not allowed near.
well, and the reason I voted, well, I didn't get to vote, I don't think, but I agreed, I think, because it's the downtown corridor. That church moved in, I mean, and granted, it was in the, my belief is you're in a commercial zoned area anyways. I'm not gonna tell one business what they can and can't do with
Well,
their business. That was my
I,
reason.
So, no, I don't think that statute requires notice.
right.
No,
No.
it didn't. He wanted to notice it.
Yeah.
And the council voted in a different direction.
Yeah, okay.
And here's I keep going back to it 100 times. I don't necessarily disagree that bar owner got the right that he did. I just want to know if the public is thinking about something that I'm not, right? And that why do they care about it? Why do they not want it there? I want to hear it before I make the decision. But I recognize that our body is the ultimate deciding factor based on merit and not on quantity of statements.
Yeah,
like
yeah.
your statement. So.
Yeah. I think this came up once in Glens Ferry with a Moose Lodge or something, and but those people, for whatever reason, had notice. This was 6 or 7 years ago, and there was a ton of people there. But yeah. No, it doesn't look to me like that statute requires notice, but there could be
Others.
noted, like the liquor license board. I don't know. You never know what's in these books.
Yeah, there's a lot of them.
So, with respect to this joint meeting, I just wanted to let you all, the both governing bodies, know that Glens Ferry took the better part of 2 years to fine tune and hack down to a approvable level the accessory dwelling unit concept. And they just, last Tuesday, I went to their meeting, and they expressed the ability, so we're gonna draft it into an ordinance, and that city council is going to approve it. But it may be, that may be a version that you may want to look at, because it is much more self-restrictive than other, and they spent a lot of time working on it, so. Just thought I'd throw it out there.
I had someone reach out about it to me today, that they wanted to do that, and I said that we're still in progress. So,
Any other questions, comments, concerns, thoughts?
Appreciate you guys taking your time.
Thank you guys. I know it's been a long day for you already, so.
Errors.
Yep. Okay, with that being said, we'll just adjourn at 5:34.
For your photos.